I'm Craig Lambert. I'm the Wood County District Attorney. I was born and raised in Wisconsin Rapids. I'm married and I have 2 children. My wife is a public school teacher. She's in her 33rd year of teaching. I'm a graduate of Lincoln High School here in Wisconsin Rapids, the University of Wisconsin-Madison, and the University of Wisconsin Law School. I've been a lawyer for 26 years, district attorney the last 10 years, and I also served 8 years in the Army National Guard as a judge advocate.
My name is Tim Giebert. I am a private practice attorney in Wisconsin Rapids. I've been practicing here for about 26 years. I'm a lifelong resident of Wood County, Wisconsin. I grew up in Burin, actually still reside there today. I come from a family of 6 kids. I went to school at St. Peter and Paul in Wisconsin Rapids and graduated from Lincoln High School. Did my undergrad at University of Wisconsin-Stout and went to law school at Michigan State University. I'm married to a lovely woman, Elizabeth. She's a prosecutor in Marathon County. I have 2 wonderful daughters. One is in Colorado, excuse me, and the other one is a junior at Madison. My dad, Ken, worked in the mill all his life from 18 until he retired. My mother's a homemaker and is probably the most wonderful person I know. So that's a little bit about myself. I have practices in Rapids and in Marshfield. Well, a lot of people say justice delayed is justice denied. And so a lot of people want to move things through the court system faster because it gets a better result for everybody involved. So I'm interested in developing a veterans court and a diversion program and an OWI court. So I think with an added judge, it makes sense for that judge or another judge to free up their time to be able to do something that actually, at the end of the day, probably will speed up and, more importantly, benefit the community with those added extra programs.
I think it's primarily a numbers and efficiency issue. I think it'll be good for victims of crime and parties in all kinds of cases. It's, I think hopefully cases will be scheduled more quickly and processed more smoothly. It really is a numbers and efficiency issue. It's like if you needed some plumbing work done and the plumbing business has 4 plumbers instead of 3, hopefully your job is going to get done sooner. Or you need a medical appointment. If there's 4 doctors in the office instead of 3, hopefully you get seen by a doctor sooner and treated more quickly. So I really do think it's a lot like that. 4 judges instead of 3, I think, should increase access to justice and do so in a better time frame. Those are good questions. Judges have a lot of discretion at sentencing. There are some cases where there's mandatory minimum penalties, but for the most part, in most cases, sentences are totally up to the judge. There is a legal framework, though, that guides judges when they're making sentencing decisions. Judges under the law are required to first consider probation, and that should be the disposition unless probation, for whatever reason, isn't appropriate. And then there's 3 primary factors judges are supposed to consider: the gravity of the offense, the need to protect the public, and the character of the offender. There are also less primary factors, but things judges should still consider: the impact on victims, society's interest in seeing that people are appropriately held accountable for the crimes that they commit, deterrence, and punishment. Sometimes people just plain deserve to be punished for the bad things that they've done. Regarding alternatives to incarceration, certainly in appropriate circumstances, I would consider those and do those. In fact, most crimes that come through our system don't result in jail time or prison time. And it's really, that decision is really driven by the seriousness of the offense. There are some crimes that are so serious that lengthy incarceration, of course, is necessary and appropriate. But there's a lot of crimes for which no time in jail is appropriate. I can also say that while most people that commit crimes in Wood County should be and need to be punished for the crimes they've committed, there are some people that could benefit from treatment and diversion programs, and I'm hoping as judge we can maybe start using more of those treatment and diversion programs as well.
So a judge in a criminal case has a great deal of discretion. There are certain mandatory minimums. I'm not necessarily a big fan of mandatory minimums. A judge, when they sentence, they have 3 factors. One is the gravity of the defense, or the offense. The second one is the need to protect the public, and the third one is the character of the defendant. And obviously, sometimes the first one, the gravity of the offense, some people deserve to go to prison, some people deserve to go to prison forever, but that's on the most serious crimes. A judge always has to consider probation before a jail or prison sentence. And when you take the factors of the character of the defendant, sometimes everybody makes a mistake. And if they're a first-time offender, and we have diversion programs, we don't currently in Wood County, but that's one of the things I would love to develop as the judge in the newly created Branch 4. As an alternative to jail, one of the things is community programming and restorative justice programs. That should be an alternative to any jail. Doesn't necessarily mean they shouldn't be placed on probation, but before considering the jail, if they can help other people because of the mistakes they made, and that will avoid someone else going to jail or doing something foolish or, in fact, sometimes criminal, I think that's something that needs to be taken into consideration and to account. A mentoring program for people, first-time offenders, or in a veterans court, a mentor that someone has gone through there, or a mental health facilitator, I think are very, very important. If we can get people to avoid further criminal activity, I think if it's not a very serious offense, that should be the first line of defense. So when a judge currently sets bail, the primary purpose is to ensure that that person comes to court for their next court appearance. One of the primary concerns that I think a judge needs to consider is the protection of the public. And that can range from a high cash bond to the denial of bail outright if it's a serious enough crime. But bail needs to be looked at, and we actually have a referendum that people will be voting on April 4th, which makes the judge, and I think rightfully so, consider the prior criminal history of any particular defendant. So when a judge looks at it and considers all the factors, they need to set an appropriate bail, whether it be for that person's own recognizance, or whether it be a high cash bail, or if the offense is serious enough to deny it outright.
Yeah, I prefer a hybrid approach, and what I mean by that is right now under the law, judges are supposed to first consider, when they're deciding whether or not there should be a cash bail, whether or not the person is going to return to court. I think judges should also legally be allowed to consider other things, like the need to protect the public and the impact on victims. So most people that come through our system charged with crimes don't get cash bail. Most people are released on signature bonds with conditions on their bonds that can protect the public, protect victims, and other things that need to be taken into consideration. But sometimes high cash bail is appropriate, and judges should be able to consider more than just whether or not the person is going to come to court when making those decisions. Yes, they certainly are, and judges should always strive to maintain the independence and the integrity of the judiciary. So there's three primary sources of an ethical code for judges. The first is laws, the Wisconsin statutes. Chapter 19 provides a code of ethics for public officials, all public officials, not just judges. Now those statutes in Chapter 19 are primarily financial and other conflict of interest laws. Public office is a public trust, and judges and other public officials shouldn't enrich themselves or their families through their jobs, and that's primarily what Chapter 19 deals with. There's also rules of professional responsibility or code of ethics for lawyers. That code, though, or those rules mostly apply to practicing lawyers, not so much for judges. But then there is a code of judicial conduct, and perhaps that's more on point to answer this question. But there is a code of judicial conduct in Wisconsin that's set by Supreme Court rule, and that's enforced by the Judicial Commission.
I believe, particularly, it's Chapter 60 of the Supreme Court rules, that a judge has to act with impartiality and within certain parameters. And so a judge is under, as attorneys are, a certain code of conduct. So a judge has to recuse himself from a case when he cannot be partial, because that is the most important thing in our courts, to respect impartiality, and every judge should act impartial. If they're unable to do so, whether they have a personal bias, they have someone that they know is a litigant in front of them, or they have a pecuniary interest, they must recuse themselves. There is no gray area right there. And I think that is probably one of the most important tenets of the judiciary.
Certainly if a judge has a financial stake or a family stake or a personal stake in a case, that judge should recuse himself or herself. If a judge has personal knowledge of the facts in dispute in a case, such that that judge could actually potentially be a witness in the case, then of course the judge should get off that case. There's other things though which I think also need to be taken into consideration. Judges should always be careful with their associations, their personal associations, their social associations. And what I mean by that is that judges have a responsibility to always not just be impartial, but to appear to be impartial. So if a judge has a close personal friendship with a party in a case, the judge should recuse himself or herself from that case. If a judge has a close personal friendship with an attorney for a party in the case, the judge should strongly consider recusing himself or herself in that situation as well. Judges have an obligation to make sure that there's public confidence in the judicial system and should always strive to maintain that impartiality, the appearance of impartiality, independence, and integrity. I've devoted most of my professional career to public service. I have been a lawyer for 26 years. I've been the district attorney for the last 10 years. I've successfully prosecuted thousands of crimes: homicides, sexual assaults, crimes against children, domestic violence, impaired driving, and others. I'm supported by every chief of police in Wood County and dozens of other law enforcement officers. I also served 8 years in the Army National Guard as a judge advocate. I believe that my background, my experience, and my values make me the best candidate for this position. I can also tell you that it's been my experience that when people come to court, they just want a fair shake. They want to be treated with dignity and respect, and they want a fair opportunity to be heard. If I'm judge, when people come before me in my courtroom, they'll get just that. They'll be treated with fairness, they'll be treated with dignity and respect, and they're going to get decisions based on the facts and the law and not some improper extraneous factor. Thank you.
So I have been in private practice for 28 years. I have done just about every area of law. I've participated in homicide trials. I participated, excuse me, in sexual assault and very, very, very serious matters on the criminal end. And if you ask any judge, the judge will tell you that the easiest area for a judge is criminal law. The more difficult areas are the civil litigation, the family law. And as an attorney for the past several years, 28 years, I have represented criminals. I have represented people that were the victims of crime. I have represented people in divorces. I've done all the mediation for Wood County for the last, I believe, 10 years. I've been the mediator for Clark County. I have practiced juvenile law, probate law, contracts, complex civil litigation. My opponent has indicated that he's an expert in criminal law and therefore everything else is easy. That's completely not accurate. I have been the guardian ad litem for children in divorces. I have acted as an advocate for parents on one side of a divorce or on one side of a custody matter. I've acted as mediator, so I've seen everything. And you know, while someone who's charged with a crime, they're in a very difficult position, but someone who's going through a complex civil litigation, a probate, or a divorce, those are the most important things in their lives. I think they deserve a judge who has actually practiced in that area, who has experienced in that area, and that's me. I've had numerous people throughout the years that I've represented on the other side, whether it be days, weeks, years, or decades later. They've come to me when they've been on the other side. And they'll tell me almost uniformly that we came back to you because you treated, when I was on the other side, me with respect and dignity and were fair and had a very good demeanor. And those are the qualities that I think people want on the bench.